Yes.
Jurors are in the courtroom.
Good morning. Thank you all for returning. Yeah, I need you guys standing for just a moment. You're going to go ahead and take an oath. But were you all able to abide by my instructions during the recess? Nobody did any independent research or looked up anything or watched the news or anything? All right. If you would, please raise your right hands to receive the oath from Madam Clerk.
Do you solemnly swear or affirm that you will well and truly try the issues between the state of Florida and the defendant Curtis Reeves and render a true verdict according to the law and the evidence, so help you God?
Okay, you can be seated. Thank you. All right, ladies and gentlemen, and just a housekeeping matter real quick. I know some of you had inquired about a letter that I can get for your employers. How many of you need those? All right, number 2, 3, 4, 10, 9, 8. So, okay, all right, and you'll have those probably at the next break. All right, so I've got a few instructions for you, and then we are going to move into opening statements. All right, ladies and gentlemen of the jury, you have been selected and sworn as the jury to try the case of State of Florida versus Curtis Reeves. This is a criminal case. Mr. Reeves is charged with second-degree murder and aggravated battery. The definition of the crimes charged will be explained to you later. The state's charging document, which is called the information, and I read that to you earlier last week, is not evidence and is not to be considered by you as any proof of guilt. It is the judge's responsibility to explain the law to you, and it is your solemn responsibility to determine if the state proved its accusation beyond a reasonable doubt against Mr. Reeves in accordance with the law that I provide you. Thus, the province of the jury and the province of the court are well defined, and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Testimony by witnesses is evidence. Documents and other exhibits also may be produced as evidence. After the evidence has been presented, the attorneys will have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will instruct you on the law applicable to the case. After the final instructions are given, you will then retire to consider your verdict. You should not form any definite or fixed opinion on the merits of the case until you have heard all the evidence, the argument of the lawyers, and the instructions on the law by the judge. Until that time, you should not discuss the case amongst yourselves. Your verdict must be solely on the evidence or lack of evidence and the law. I now instruct you not to communicate with anyone, including your fellow jurors, about this case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. You cannot do any research about the case or look up any information about the case. If you become aware of any violation of any of these rules at all, please notify court personnel immediately. During the course of the trial, the court will take recesses, and you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about this case, tell him or her that you are on the jury trying the case and ask that person to stop. If he or she persists, leave that person at once and immediately report the matter to the bailiff, who will advise me. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you are in the courtroom. Turned off means that the phone or other electronic device is actually off and not in a silent or vibrating mode. And the reason for this is we've got microphones all around the courtroom, and even if your phone is on silent and it starts vibrating, it picks up in the microphones. You'll hear it. I'm sure it'll probably happen sometime during this trial. You may use these devices during recesses, but even then you may not use your cell phone or electronic device to find out any information about the case or communicate with anyone about the case or the people involved in the case. Do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each recess, please double-check to make sure your cell phone or electronic device is turned off. At the end of the case, while you are deliberating, you must not communicate with anyone outside the jury room, and you will not have in the jury room any cell phones, computers, or other electronic devices. If someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay, but you will leave your cell phones on the table there while you're deliberating. This case must be tried by you only on the evidence presented during the trial, in your presence and in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation of their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you're in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed in the trial. And all of these rules apply throughout the trial. Once you've heard the magic words that you are now discharged from your service as juror, I don't care what you do, any of that stuff, but between now until that time, these rules apply. Jurors must not have any discussions of any sort with friends or family members about the case or the people and places involved. So do not let even the closest family members make comments to you or ask questions about the trial. In this age of electronic communication, I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. What are the reasons for these rules? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries on your own, the trial judge has no way to make sure that the information you obtain is proper for the case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you find. That is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against him or her, and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions such as serving time in jail, paying a fine, or both. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer. During the trial, it may be necessary to confer with the attorneys out of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will last. When such conferences occur, they will be conducted so as to consume as little of your time as is necessary for a fair and orderly trial of the case. If you would like to take notes during the trial, you may do so. On the other hand, of course, you are not required to take notes if you do not want to. That will be left up to you individually. You have been provided with a notepad and a pen for use if you wish to take notes. That's in your envelope there. Any notes that you take will be for your personal use. You will be able to share your notes with your fellow jurors during your deliberations. Not any time other than that, of course, because you're not going to discuss anything amongst yourselves prior to your deliberations. However, you should not take them with you from the courtroom. During recesses, just leave them on your chair and the bailiff will watch over them. After you have completed your deliberations, the bailiff will deliver your notes to me and they will be destroyed. No one will ever read your notes. If you take notes, do not get so involved in note-taking that you become distracted from the proceedings. Your notes should be used only as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. At this time, the attorneys will have an opportunity to make opening statements in which they may explain to you the issues in the case and summarize the facts that they expect the evidence to show. After all the evidence has been received, the attorneys will again have the opportunity to address you and make their final arguments. The statements that the attorneys now make and the arguments that they may later make are not to be considered by you either as evidence in the case or as your instruction on the law. Nevertheless, these statements and arguments are intended to help you properly understand the issues, the evidence, and the applicable law. So please give them your close attention.